Our keynote this afternoon is some real everyday sheroes. These women are a sheer delight. I've gotten to know them over the course of planning for this event. They're sheroes who are creating equitable workforce for women in technology. Ella Zheng from Sanford, Heisler, and Sharp, and Felicia Medina from Medina Orthwine are just taking on the tech giants and paving the way for an equitable path for women in technology. And I am pleased to present Ella and Felicia.
All right, can you hear me? So great. Good afternoon, everyone. It is a pleasure to be here in the Buckeye State with a group of women and women allies who are holding it down in tech. And thanks to Bonnie and her crew who invited us here today and for giving us these Wonder Woman bracelets where we feel even more powerful already. My name is Felicia Medina, and I'm an attorney in California that has been doing gender discrimination class action work in a variety of industries for over 8 years. I've seen it all, and what keeps me going is the tenacity of women like you who won't accept the status quo.
Hi, everyone. My name is Ella Zheng. I'm an attorney at Sanford Heisler Sharp. I represent employees in individual and class action cases that involve gender discrimination and other types of discrimination. I'm also deeply involved in the tech community in Silicon Valley. Not here, yet.
So when Ella and I met to prepare for today, I shared a story with her about a recent interaction I had that I want to share with you all. As part of my new self-care plan, after not having been to the optometrist since I was about 13, I took a break from my busy work day and went to get my eyes checked. A male doctor came in to examine me and asked what I do for a living. I told him that I do employment discrimination class action work and that I specialize in equal pay. After making sure that I actually was a licensed attorney, he proceeded to ask me how equal pay laws were fair to employers, being that women work less because of family obligations. When I told him that the research shows that women with children are actually more efficient because they have to be, he didn't seem persuaded. So he asked if the pay gap could be attributed to the fact that men are more particularly suited for STEM jobs and that there just isn't enough women in the market to fill these roles. After going through a litany of the usual arguments we have in our arsenal to combat that type of sexism, I also told him again, now more than ever, women are graduating with STEM degrees, and the market justification for inequity in the workplace is a common refrain by companies that doesn't hold water. Needless to say, what I thought would be an everyday activity, like going to the eye doctor, turned into a reinforcement of how pervasive sexism is.
So when Felicia shared her story with me this morning, I was not surprised, but I was very saddened. Her experience and many others show that there's a lot of misinformation about women in the workforce, especially women in STEM. And this is particularly problematic if your company's leadership buys into that kind of stereotypes, either unconsciously or consciously.
Most of us are all too familiar with the fact that women make 80 cents on the dollar that a man makes. The gap is significantly wider for women of color. Black women make 63 cents on the dollar, and Latina women make 54 cents on the dollar. Although the pay gap has narrowed over the past few decades, a 2017 report by the American Association of University Women estimates that women will not achieve pay equity until 2119.
Being new to this region, Felicia and I were surprised to find out that Ohio's gender pay gap was wider than the national average. In Ohio, for every working woman, she makes 75 cents on the dollar that a man makes. And Ohio ranks number 10 among all the states that with largest gender pay gap.
So we can talk about these stats and the veracity of the data all day, but today we wanted to get a sense of what all of you are experiencing and ask you some questions. So it's a safe space here, so Ella, let's ask some questions and get a feel for what the local pulse is here.
Sure. So raise your hand if you work in a company that the leadership is dominantly men. Wow. Okay. What about whether you know your pay stacks up against your male counterpart's pay? So how about Have you had the experience that you are the only woman at the table? Okay. What about those who have been told that you should spend more time with your family? Okay. And how many of you have been subjected to unwelcome comments because you are a woman? Okay. And then what about promotion and development roles? Have you been turned down of any of those opportunities that you think you actually deserve? Okay. What about whether you have been left out of formal or informal networking opportunities at your company? Okay, great, thank you. So last two, do you feel that your leadership and company's HR have turned a blind eye to discrimination complaints and promotion issues in your company? Okay, I promise last one. Do you feel that your career might be negatively impacted because you have a family? Okay.
So the questions we've asked are the things that we confront in our practice every day from women, not just in California, but across the nation. And that's the reason why we do what we do. Your show of hands indicates that women face many impediments in the workplace in addition to pay disparities. We are called sweetie and told to smile. Sexual harassment is still rampant. I'm sure many of you have seen the Susan Fowler blog about Uber detailing widespread harassment and an ineffective response on the part of HR to address that harassment. Claims of valuing diversity is often corporate window dressing. Our tone or management style apparently still creates a lot of problems, especially for male employees. Our emotional intelligence is often called into question. We are interrupted and belittled by male coworkers and superiors and judged for asking for higher pay or for a promotion. Our contributions and accomplishments are ignored, minimized, or underappreciated. Pregnant women and mothers are frequently accused of taking advantage of accommodations or leave policies, as well as being accused of being uncommitted to their jobs.
I'm sure some or all of you have experienced what Felicia just described. And a lot of you also know that promotion and representation in leadership and management role is another significant problem in tech. Many surveys have found that among all major industries, tech industry is near the bottom in terms of female leadership and management roles. Promotion rates for women clearly lag behind those for men, and the disparity widens as you advance. At the first level of management, for every 100 women promoted, there are 130 men got promoted. And in 2015, there's a survey showing that 90% of new CEOs was promoted or hired frontline roles, and every single one of them was men. And only 1 in 5 senior executives is actually a woman.
So women are negotiating as often as men, but face pushback when they do. Women negotiate for promotion or compensation increase are 30% more likely than men who negotiate to receive feedback that they're bossy, too aggressive, or intimidating. Women also get less access to senior leadership roles. Women and men both view sponsorship by senior leaders as essential for success, yet women report fewer substantive interactions with senior leaders than their male counterparts do. And this gap widens as women and men advance in a company.
So with all this going on, it's unsurprising that there has been a number of significant class action lawsuits involving tech. More and more STEM women are coming forward and addressing the pervasive gender discrimination in this industry on a day-to-day basis. While a large amount of this work happens behind the scenes in meetings with HR, management, or coworkers, recent lawsuits have shed a light on this disparate treatment, giving some national attention. Major tech companies throughout the nation have been hit by gender discrimination class actions that point to the systemic issues of pay, promotion, and caregiver discrimination. We often hear about bad apples when we talk about gender discrimination, the idea that discrimination comes from a few select individuals who's willing to show an explicit preference for men over women. In reality, these bad apples are just the tip of the iceberg.
What these recent lawsuits have shown is that the policies, practices, and procedures of companies often allow for and reinforce unconscious bias against women, which have a real impact on their lives. Let's take the recent example of the case against Google. The United States Department of Labor Office of Federal Contract Compliance Program, otherwise known as the OFCCP, performed a statistical regression analysis of the compensation data for approximately 21,000 employees in Google's Mountain View office. What they found was systemic compensation disparities against women across all of Google's workforce. Specifically, they found 6 to 7 standard deviations between compensation of male and female employees. Many of you are math experts, so I won't get into the specifics of what the statistics mean. However, just know that courts generally recognize 2 standard deviations as the requisite threshold for proving discrimination. So the fact that the OFCCP's analysis showed standard deviations that are more than 3 times this threshold is very significant. Disparities like this were not caused by a few bad apples. They are the result of wide-sweeping company policies and corporate cultures.
And another example we can use is the ongoing case against Microsoft. So very similar to the Google case, the Microsoft case also focused on the disparity in terms of pay and promotion between men and women. And also very similar to Google, the cause of this discrimination was not just a few bad apples, it's actually some systemic issues in the company. And that case shows that the disparities are the result of a company's policies ingrained into the fabric of the institution. And in the case, particularly the female Microsoft employees cited that stacked ranking was very unfair to women. But this is a method that Microsoft has been using throughout 2014 to evaluate, compensate, and promote female employees. And what the lawsuit told us is that that kind of ranking system, in that kind of ranking system, females usually receive lower scores than their male counterparts.
So combating institutional forces like this can seem daunting, and they are even more difficult when dealing with companies that are resistant to change. Thankfully, these types of efforts, if they end up to be successful, not only compensate women for their losses, they also give women the opportunity to alter the company policies and keep women from facing discrimination in the future. They also bring relief to thousands of women facing discrimination, many of whom are unaware that they're being underpaid or underpromoted, and many who, despite their knowledge of discrimination they faced, do not have the time, energy, or means to bring a lawsuit themselves.
Some of you here might have heard the recent case of my firm against Qualcomm in a gender discrimination class action case. In that case, because of the tremendous courage and the perseverance of the 7 female plaintiffs, we were able to achieve an unprecedented $19.5 million settlement in the case. And all of these was achieved in less than 2 years and without the cost, stress, and time that's associated with litigation. Instead of going through all the strains, what we did was sit down with Qualcomm and their counsel, conducted a lot of discovery, and hammer out a settlement that would bring positive changes to the company and its employees. In order to make sure the change is long-lasting, we also get Qualcomm to pledge an additional $4 million to cover the costs associated with changing the company's policies that led to the gender discrimination in the first place. The programmatic relief we achieved in this case was some of the most extensive policy changes that agreed to by a company as a result of a class action case. And Qualcomm was willing to go down this route, not because it cares about its employees, not owning that it knew all those women step forward was just the beginning, but it's also that they realized addressing gender discrimination proactively is in their best interest. Reducing the amount of harassment, sexism, exclusion, and general disparate treatment female employees face increases their productivity in their workplace and also improve the company's efficiency as a whole.
So my firm was also involved in the Qualcomm pre-suit class settlement, and what that meant was that we front-loaded all the work that 4 to 5 years of litigation would be compacted into a transparent process by which we all sit down, and it took a lot of work on behalf of all 7 of those women. And what also was in the background of this is that when you publicly out discrimination, you can do substantial reputational harm to a company. No company wants to be known for being discriminatory. That type of reputation impacts sales, recruitment, and the morale of employees that currently work at the company. As evidenced by the experience with Qualcomm, companies are finally starting to understand this, but it takes a lot of work to get there, and it will take a lot of work to ensure that we keep pushing in that direction. Specifically, it will take more courageous women willing to speak up against the powers that be, women who are prepared to share their stories and advocate for themselves and other women.
So you might ask, what can we do to combat these gender discrimination and disadvantages in your workplace? For starters, I would say document everything. From microaggressions you experience on a day-to-day basis to tracking the career progressions of your male peers and know who's supporting them. At performance review time, state your review that you are interested in a promotion or development opportunities, and also ask for a detailed development plan that lays out objective metrics.
So externally, there's also things that you can do. You can band together with equal rights nonprofits and legislatures to enact more robust, state-based equal pay legislation. The equal pay laws at the federal level and here in Ohio are somewhat antiquated in terms of how you prove pay discrimination. The laws are fixated on the phrase equal, whereas in California, new equal pay laws focus on the idea of comparability, which more accurately mirrors modern corporate America. The presence of this new California Fair Pay Act was one of the main reasons why we were able to settle the Qualcomm case on a pre-suit basis. It was pretty evident that Qualcomm was not going to be able to overly disaggregate its data to show no pay disparities, or that it was not going to be able to overcome the very high burden the legislator put on employers to justify pay disparities if they exist.
Additionally, in our experience, the most important way to combat gender discrimination is support each other and band together. Banding together makes a stronger voice, makes it less personal and less offensive, and makes it very hard to retaliate. In the workplace, we need to look out for each other. We need to recommend your female colleagues for promotion and advancement opportunities. We need to mentor female colleagues, teach and learn from each other, coach and advise your female colleagues on how to successfully negotiate for a higher pay or a higher title.
So women affinity groups can do much more than serving as a support group or a development or networking group. Your affinity groups can push for regular pay equity analyses so that companies can be held accountable for pay and promotion gaps. In your affinity groups, don't be scared to ask if the company has already performed these analyses and what the results were. Then, using your STEM and tech background, you can question the variables that are used to see if it creates a regression or a model that matches your workplace. Your group should also push for anonymous company-wide surveys about corporate culture and bias, so that way female employees can anonymously give their input to the company and voice their concerns without so much fear of retaliation. This type of evidence was very compelling in the Novartis trial that we talked about earlier, or may mention more today.
And remember, when you're subject to gender discrimination, information is power. You have to know your rights. Most companies have policies regarding discrimination, harassment, and retaliation. Knowing these policies in and out is very important. And there are also resources online that you can find that would describe your legal rights in your workplace, which varies among the states, but they are very helpful to you. And again, when something specific happens, document it. Send an email confirming the details of a conversation you had with your management or leadership, and make a note in your performance review about your goal for advancement. Of course, as Felicia mentioned, fear for retaliation are valid. And use your female fellow colleagues as a resource, or be a resource to them. You can also seek the advice of a professional coach or a lawyer to find out what's the most strategic way to combat discrimination in your specific workplace.
It's also important of the complex, when we're talking about gender issues, that we have a more holistic way of looking at this. Just because an issue is systemic does not mean that all of those marginalized are impacted in the same way, even with respect to gender discrimination. When doing this type of work, whether it's in the context of a lawsuit or whether you're simply speaking up in meetings with your peers, manager, or executives regarding issues of equality, Maintaining an intersectional perspective is crucial. You can't talk about gender issues without acknowledging the unique circumstances facing women of color, older women, and women with disabilities. Ignoring these differences, which unfortunately happens too often, leads to inequitable relief for those facing discrimination. As the amazing Kimberly Crenshaw once said, if we aren't intersectional, some of us, the most vulnerable, are going to fall through the cracks. Intersectionality played a huge role in the Novartis pharmaceutical class action trial that we took all the way to verdict in the Southern District of New York in 2010. The lead sales rep in that case who testified at trial was an African-American woman who not only was the #1 sales rep nationally, she was the #1 sales rep internationally, but yet the company wouldn't promote her. Overall, in the Novartis trial, because of the work of women who came from various racial, social, economic, and religious backgrounds, we reached a jury verdict of over $253 million. That's the largest gender discrimination class action verdict in the history of the United States. The jury was diverse, and our women's experiences spoke to them. Not only that, it's not diversity for diversity's sake, it's staying true to the experiences of all women, and that's what inclusivity really means, and that's the value of it.
And the same situation happened in the Qualcomm case that we just mentioned. Our named plaintiffs come from a diverse set of backgrounds. They were and will continue to be involved in creating and monitoring the changes to the company policies. And the diverse opinion they provided during the discussions was just insurmountable. And as we discussed, the types of Qualcomm the types of trainings that Qualcomm should provide with its employees, the plaintiffs that we had all sorts of perspectives and opinions, share their experience and their suggestions. This phenomenon that the diverse perspective help with policy change is backed by social science research as well. Study after study have found that diverse groups of employees come up with more representative and more creative solutions to complex problems. What these cases have shown is that just like the importance of addressing discrimination, maintaining an intersectional perspective is not only the right thing to do, it is the smart thing to do.
So legal action is an important tool in our arsenal to combat discrimination, harassment, and retaliation in the workplace. But it's one of many tools we have, and quite frankly, it really should be one of last resort. Litigation is a very imperfect process. And as we've mentioned before, the most important tool that you all have is each other, banding together, supporting each other, and lifting each other up. Look out for each other, share your experiences with one another, and develop and advance each other, and really celebrate each other. When someone stands up, don't forget that she is standing up for all of us. She's providing a voice. Join her, support her. If your company already has a women's affinity group, make it stronger, and make sure that it offers more than just networking. And lastly, don't forget the women of color. Bring them into the fold, lift them up, support them, and develop and advance them.
The women in our Qualcomm case told us to tell you today that before coming together, they had no idea of the female employees were experiencing the similar bad advantages. They feel relieved and so proud that they were able to make the impossible possible just by being together. And they hear you from afar, they lived your experiences, and an important piece of information we want to share with you is that never doubt yourself and the power that lies within.
So with that, we'd like to open it up to questions, so that way it's not just a bunch of talking head lawyers at you. So if you have a question, feel free to raise your hand. And Bonnie, I think, has a mic.
Testing, okay. So you said knowledge is power, which is so true. And I am aware that I make less than my male counterparts at work. How do I guess, I think I can prove that within the company just because of my role, but I also want to know what other people that are in my role in the state of Ohio or even in Columbus make. Is there a way for us to find, just as kind of average citizens, the kind of comparable salaries and pay structure? I know some of that data is so hard to get and it's very expensive, but is there advice that you have on each of us kind of individually getting comps?
Yeah, so market data, market research data, a lot of companies will use it to benchmark their pay to kind of keep up with their competitors. But also the Department of Labor, although not perfect, will definitely give pay ranges per role, so you can kind of see and have that as an additional argument to support the fact that you think you're being underpaid. What's key when talking about pay is to show that what you're doing is essentially the same as your male counterpart, and that you're comparable in terms of age, education, and other variables like that, and in terms of results. And so it's not just the market data, it's also internal to the company and the results that you produced and how big your role is and how comparable that is to the other person.
And relating to the piece of advice that we gave earlier, you should not shy away from talking to people outside of your company, not letting alone inside. You should always be open about, your pay. Transparency always works better for females. And in some of the states, for example, in California, employers are actually prohibited from putting any restrictions on employees inquiring about the salary information.
Yeah, dovetailing off of that, there's specific prohibitions in California that state if you want to talk about your pay or other terms of conditions of employment, that your company cannot retaliate against you or prohibit that in a policy document. So looking at your company's policies and practices and what state you're in to see, does that specific provision exist either in law or does that specific prohibition exist in the policies? Because you want to be aware before making any kind of move, what are the risks? So that way you can make the best strategic move that you need to make, either by going to someone that you think is your ally, a mentor, someone who seems to actually care within HR, having your data kind of ready, knowing what the counter arguments may be. If this person, your comparator, is 1 or 2 years, older than you, maybe not so big of a deal. If he's been in the role for 10, 15 years, then it may be legit that there's a bit of a pay disparity there. And then also online, you can find out what are your damages. In equal pay law, you get liquidated damages, meaning like if you have been underpaid by $13,000, you double the damages per year. So when you also get a pay equity analysis just out of the blue, oh, we're going to up your pay and it's kind of off cycle, that's a sign that you've been underpaid because they've done some analysis and they see that you're underpaid. And so what women don't do is then say, okay, well, I want my back pay and I want it doubled per the statute, which you're entitled to do. But then again, it's one thing for me to say all this. It's another thing for you to actually navigate within your company without kind of putting yourself too much at risk.
So what would you recommend for individuals, not my current situation, thankfully, but in an instance in which there is an explicit corporate policy that prevents you from discussing regarding pay, and you happen to have had that discussion anyway, and there's potentially not only a huge disparity, but you're now also both being reprimanded officially for having that discussion?
So you're kind of caught in a kind of catch-22 there, because if you don't have the specifics of the prohibition of talking about your terms and conditions of employment in law, you'd have to go the extra step and actually talk to a lawyer, because even if it's not codified in law, there could be case law that establishes this right, or at least some judges trying to see the unfairness of this situation and may have given a more favorable opinion in one case, and you can kind of you really have to get more legal with the situation, actually, because if you don't have that protection and under the state law, then the company's not on notice that that is unlawful. And if you've already kind of experienced the retaliation, then anything from a peremptory level, working with your affinity groups to demand more pay transparency in addition to more robust anti-retaliation provisions, then that's when you're kind of in the very much of a disadvantage because the retaliatory action has already occurred. So I think getting more, this is like one of those instances, even though I said like litigation should be a last resort, this is one of the instances where I think like looking more at this from a legal perspective with a lawyer would be helpful.
And I would say when you have doubt, try talk to the HR as well. I know it's very difficult, but try to make friends with your HR because HR has a lot of information. They have a lot of information about the company, about the employees, all the pay and the promotion information. It might take a long time, but try to have an open conversation with your HR about any doubts that you have. If you feel that the company's policy is not in compliance, talk to HR about it. If you feel like you have been subjected to adverse action from your conduct that you inquired about salary or other terms and conditions of your employment, talk to them as well. There usually is a internal grievance procedures and policies in your handbook. So read your handbook, understand it, know in and out about the company's policy is really important too.
I have a quick question. So I know initially you mentioned that in Columbus, the difference between the salary range is very high. Do you have idea why it is so, like it differs so much in Columbus versus in any other place?
So there's a lot of academic debate about what causes the pay gap. A lot of people think that it's a result of discrimination. Other people think that there's other factors that come into play, and that is family obligations, in addition to kind of sex-segregated jobs. If you are a janitor versus a maid, usually janitors are thought of as men-occupied jobs, and maids are thought of as to be female jobs. And so the fact that the janitor may be performing similar work to the maid, they still think it's justified to support what people think are the main breadwinners in paying someone $20 an hour versus the maid who makes $18 an hour, because maybe her job is seen as more soft skills and interacting with patrons more, and so that's the justification for kind of giving that wage differential. So, specific to Columbus, there could be many things at play with respect to this wage gap. And also, it really depends on how much protections you have for family medical leave and other things that make work-life balance and having a family more workable for you in a state in a state specific kind of case study analysis. And one thing, companies also will do technical versus non-technical, and pay, even though you all have technical backgrounds, and pay people less that are non-technical versus technical, even though you all are kind of producing this one main product and each are essential. So I don't have an exact answer for why this pay gap is more prevalent in Ohio, but those are some of the factors that are hotly debated with respect to why there is even a pay gap to begin with.
I have a quick question. Have you noticed any kind of difference in the fact that Ohio, for example, is an employer at will state? So to me, listening to what's being said, and I know how California laws are so different, if someone starts a movement kind of like of this nature in Ohio, what's to say that the employer won't shut it down by just firing you, because Ohio can just get rid of you for any reason? Have you ever noticed any differences for states like that?
So most states are at-will states. So you can leave your job for any reason, and an employer can theoretically fire you for any reason. If it's a mass layoff, then there has to be notice and things like that. But in most states, under Title VII, which is a federal anti-discrimination statute, if you engage in a protected activity, meaning you oppose discrimination in the workplace, complain about sexual harassment, or complain about unequal pay, then if that is causally connected to that adverse employment action, to that termination, then that's prohibited by law at the federal level. At the state level, you may get even more protections, and in addition to bringing a cause of action, a claim in a lawsuit under a statute, you may have other available means to bring an additional retaliation cause of action. So I don't see it so much as a difference between an at-will state versus a not at-will state. Majority of states are at-will. In the right-to-work states, that has more to do with unions than it does have to do with private employers. So I think there may be something else at play here.
And one thing I want to add is, given the nature of at-will employment, I think that's when you really need to talk to a legal professional at an early stage. Because people shouldn't think that, oh, I only go to a lawyer when a real dispute happens or when I'm facing some imminent harm at my workplace. I think you should start talking to a lawyer when you feel that something's going wrong, because lawyer can play a lot of roles in the entire process, even in your internal grievance procedures. Even when you're just talking to HR, lawyers can point you to buzzwords that you need to use or identify, because sometimes when you just say, oh, I feel like the treatment I receive is unfair, in that instance, it might not be enough. You have to specifically point it out that you felt that you were unfairly treated because you are a woman, or because you have caregiver responsibilities, or because you are a woman with disability. So you have to be very specific about your complaints, both internally and externally. So that's the thing I think a lot of people should bear in mind. And most employment litigation cases are on a contingency base. So, if financial is a concern, then I hope that answers that question.
Right here. So I guess a comment about earlier, I have experience where I found out that a coworker, made 20% more than I did in the exact same position. We weren't supposed to talk about it, so that was already, grounds for termination basically at that point. But in going to HR and trying to get a raise to correct that, HR said, well, we can't justify a 20% raise, so sorry. So I guess a short question is there really no other alternative at that point besides going to a lawyer, right? Because we're trying to make more money, and you guys are expensive. You're worth it, but you're expensive. So that's just a short question. And then another thing is, when you are kind of, let's say you're looking at a job offer somewhere else, is there a correct way to go about finding out about the benefits, like maternity leave or something, because it does play a lot into you looking at offer if you're at that point. A lot of times they don't share that up front, and it can be kind of difficult to dig for that information about the PTO or the medical, and I don't know what you're allowed to ask.
So the first question is about, there's a pay disparity. Short of going to a lawyer, what can you do? Because HR has said that they're not going to make good on the disparity. So one, after you could educate them on the law and see what the appeal process would be and go through that process. The other thing is, if that doesn't work and you don't want to have to go to a lawyer, it's completely free to go to your local EEOC or state equivalent of the Equal Employment Opportunity Commission office. And there, they can send inquiries to your employer. If your employer is a federal contractor, you can also go to the Department of Labor and the OFCCP, which we talked about earlier, which was instrumental in investigating pay disparities at Google. And I don't know all their internal processes, but there are some instances where maybe you could do this on a kind of anonymous way, so you're not sticking your neck out too far. So those are options short of going to a lawyer that you could avail yourself on. It's not necessarily going to say that that's going to work or that you won't be at risk for retaliation. But at least then you've documented that you've engaged in a protected activity. So if there is an adverse employment action after that, even though you don't want to be in a situation where you've lost your job, your claim has gone way up because then your damages go up because now you're out of pay. Your second question was, remind me again?
How to get information about all the benefits and terms of employment.
So, yeah, a lot of people, you should be entitled to kind of weigh your offers, against other offers that you have. And so a lot of people won't go through the actual person that's interviewing them. They'll go through the recruiter, they'll go through HR, they'll go all through the process and then kind of ask for their final offer in writing. You can ask for their handbook as well, and that information may be in there. And that way you're not kind of raising a red flag, even though you should be entitled to, that you may want to have a child one day and you need to know what their maternity or paternal, their leave policies are. So I think going around with other actors as opposed to the person that's interviewing you, so that way you're just focusing on convincing this person with all their unconscious bias that they may have against you because of your gender, your race, or a combination of a number of things, your age, that you can do the job. And then get the information you need more so on the back end.
I echo everything Felicia said, and one thing I want to add is, in that kind of situation, expanding your network is very crucial. So I know nationwide that there are a lot of women affinity groups that sort of advance women in the workplace, advocate for each other's rights in their companies. Circles such as like LinkedIn, they have industry-specific circles as well. And within that kind of group, because it's a very exclusive group, and people are more willing to share their benefits and terms and conditions of their employment, their experience with specific employers or companies. So that kind of information and engagement would help you get more information So that's something that I want to add to how to get information about specific jobs and companies.
Very good point. Go through your informal networks from someone that has already worked there, or look at online resources such as glass ceiling and things like that to get a better sense of what other people's experiences are and what the benefits are.
Do we have time? I wanted to have you guys maybe weigh in on a scenario. I had a boss who was male. I'll fast forward. I ended up filing an ethics complaint against him within the company. I followed the right channels through HR. I talked to my HR. It was ridiculous. I ended up filing it was 22 pages. I put my name on it, and I got fired 9 months later. He didn't get fired. He quit eventually, and I had been with the company for 17 years. Other females were being targeted by this person. There were female managers who had been demoted. My team was taken away from me. I mean, it was ridiculous. It was blatant. It was obvious. I decided that I was going to stand up for myself. And fast forward 9 months later, they found a reason to fire me, which was I had an inappropriate conversation with someone. What did I do wrong? I mean, I subsequently hired a lawyer and filed a lawsuit, but nothing came of it. They told me it's not illegal to be an asshole. I mean, that was basically the extent of it, which, I mean.
So there can be very abusive people of all genders in the workplace, and I've had that conversation too with people that it's not actionable to just be a bad manager, to kind of ride people hard, to just really not care about anything having to do with that person, yell, scream. You got to link it to a protected classification. And some lawyers do a better job than others about kind of seeing how unconscious bias in your performance reviews and things like that, using certain adjectives or the adjectives that were used to you, if the link was not made clear that it was gender, and you didn't have a lawyer that would bring in other women into the fold to make it a broader, not a class action, because it's very difficult to have a class action against one bad actor, but it has been done with someone that's more recently, that's with someone that was a very notorious actor at a factory. So you usually have to have like a very central place. But from the beginning, as far as like what you did wrong, the pitfalls of litigation is that some employers will be very dirty. Yes, they are going to request to look at your cell phone and get things off your cell phone and start subpoenaing records from other employers and past employers. And so it's a dirty, imperfect gain, and you're putting, that's a very risky thing, because then you've outed yourself in an industry and gone through the pain of litigation, and even if you were to be successful, you can't recoup the pain of having to go through the litigation. You can only recoup the mental anguish associated with the discrimination itself. So in general, like I know looking back on this, you lost your job and your lawyer was ineffective. The one thing I can say is that you didn't go silently. You did stand up to this person. If he eventually left, you don't know if he was asked to resign, so maybe your lawsuit did have an impact there. And it also helps you to think that you've protected other women, not only the women he's already harassed and mistreated, but the women going forward. So I'm very sorry to hear about that, and I can hear the pain in your voice, but I don't have necessarily a solution here other than, okay, getting out of that environment is, yeah.
And one thing I think in your experience I want to point out is, as you mentioned, you filed a 20-page complaint against that bad actor. I think that's a very good thing to do, and that actually relates to an advice that we gave earlier, which is document everything. That's something that a lot of employees are not aware of in a day-to-day work, but people don't realize how important it is. A lot of we do presentations like this from time to time, and one of the most common questions people raise is, how am I going to document it? Am I just going to write it down? Is it effective in the legal action? I think people don't overthink about it. Just write down everything that you experience and you feel that's not right. It can be in the format of a journal or a diary. All this information will be very helpful no matter whether you take the route of filing a complaint with an administrative agency like EEOC, or later on if you find an attorney who's willing to take this case through the settlement and negotiation all the way up to trial. So these information, and the the flip side is that the company has a lot of control over those data and information. Most employees, when they're terminated from their employment, they don't know how to keep a record of all the email communications that they had with a bad actor and or other coworkers. So what you have to do is if you have write it down, their detailed time, events, the circumstances of the experience, that will be extremely helpful to your lawyer or any person who's going to have some decision-making power on your case.
And just writing on that, linking it, even though you can't say it, specifically, he said you're a woman. Like who really says that? Sometimes you do, and it's still not enough. You're a woman, and you should be at home, and I'm treating you differently because of this. You have to say, on information and belief, he doesn't treat my male counterparts like this. It's like you can't necessarily prove it, but you're creating circumstantial evidence of disparate treatment because of a protected classification. And with respect to notes, you can talk to lawyers on the front end to see exactly it should just kind of be the who, what, when, where, why, how, and let the lawyer kind of put the links to support your causes of action in there. And also, since we're talking about documenting, most states are two-party consent states. And so, although you may think it'd be helpful to record someone, it's often illegal. And a lot of times, especially in California, where it's illegal to record people without their knowledge, we can't take cases because we know that they've engaged in this long recording on their phone, and that's an after acquired reason that the employer could have terminated the employee, irrespective of the legitimacy of the claims that they had accrued prior to that recording. So that's why the notes with the who, what, when, where, why, how are more important than recording someone illegally, which could come back to bite you.
And just one more point to add really quick, and very similar to the situation with tape recording. Another thing is, because we've talked about document everything, and you would think, at the termination of my employment, can I download all the emails to my personal devices? Mm-hmm. My advice is do not do that, because companies have various ways to track what you did with all the emails, the business documents, your products, etc. So if they track that you've downloaded a lot of information, most of the times it contains very sensitive and confidential business information, and you don't want to be countersued for stealing companies' business secrets. So what you can do, there are other ways you can do. You can take a screenshot, or you can take a photo of the emails that you had with your colleagues. That's not trackable. You can print out a hard copy through a printer. That's not trackable either. You can, literally write down everything that exactly show on the email or work documents. That's not trackable too. So, all those information, you just have to bear in mind that, massively downloading all the document is not a good way to go, but that doesn't stop you from documenting the things. They have one over there.
You guys talked at the beginning a little bit about changing company policies to try to maybe change the environment to help dissuade discrimination against women. What are some things you could suggest, from a company perspective that people could do to, like a policy to enforce, for example?
So this practice of changing corporate policies, it doesn't happen overnight. It takes a long time to change corporate culture. There's various aspects of a programmatic relief proposal that we put in our class action complaints, and it usually involves hiring very high-level consultants that look at all the HR processes with respect to complaint procedures, look at all the outlets that women have to complain. We're doing ongoing equity analysis like we'll do in Qualcomm, where there's going to be a labor statistician giving us the results, and we get the data. Again, we get to run the data our way and under our model and go back to Qualcomm and say, no, there's a shortfall here in promotions. We don't agree that this is all fine and peachy keen. It's so, as far as company policies, there's so many aspects of company policies. An easy one would be, even though the law in your state may not require it, allowing people to talk about the terms and conditions of their employment and talk about pay transparency more specifically as being protected. But really, it's like all aspects. It's like, what is the leadership doing? What is HR doing? How are managers trained? How effective are these trainings? Is there any discussion of unconscious bias? Is there any specifically anti-bias training that follows the unconscious bias training, so that way you're not just giving people a justification for, well, we're all sexist and racist, so it's I shouldn't have to bear any responsibility for it. It's like the extra step of debiasing. So it's a long-winded way of saying, these things are 20, 30 pages long of stuff that's negotiated throughout various operations of a company to kind of get to that.
We have time for one final question.
Here's the one question too.
Do you think we'll ever get to the point in where, and probably most likely for larger companies, be held to some type of compliance audits that's more proactive, that requires companies to assess, or maybe a third party assess pay practices? Because there's larger companies now that have competencies notated. You have all the demographic information on, female, male, and work history. So all that is in there right now. It's just no one is proactively looking at it. You'd have to raise concern as an employee versus having mandates for companies that of a certain size, I understand that, to actually audit their pay practices to see if there's disparity, male, female, et cetera. Because I do have issues with kind of what you just said in how companies are applying standards, in where just because they put out a policy of, if you have a candidate pool, you have to make sure that there's a female in there. And okay, great, we met that standard, even though we were never really considering that female. We just, it was the only way that we can get through that checklist. I have issues with that, so it's not always as genuine, even though the intent of putting a policy like that out is appropriate, but it's not always executed fairly. So back to my other question, will there be more from a government perspective, or that mandate of, we needed to audit your pay practices?
I mean, we can look at this legislatively. Like, it would probably have to be a legislative fix. The Equal Rights Amendment has not passed, and there's many other anti-discrimination provisions that have been proffered many, many times that still have not passed. And what the reasons for that, we can all opine on what that is. I think it's just because it's well-entrenched racism and sexism in this country, and not kind of curing that kind of bloody history with respect to people and intersectional people. And so, can I tell you that the Department of Labor under the Obama administration was more aggressively going after tech, and because they're government contractors and doing things like the Google investigation? Yes. Do I think that's going to happen now going forward for the next 3 years? No, I don't. That doesn't mean that you're still not entitled to have private right of actions to kind of be your own private attorney general. With respect to the efficacy of various policies, there's going to be many, many debates on whether, if you have a woman in the applicant pool, you kind of check the box and move on from there. And maybe that's not really getting to the problem. But with respect to tech, a lot of company, or kind of more people-friendly companies that really bank on their public image, like Whole Foods, they're posting everyone's pay, not by name. So there could be, but it takes resistance. It takes many different things to get to that point where there's complete pay transparency. And, so that way, that's half the battle here with respect to women. No one is comfortable talking about their pay. It's kind of built in our heads that it's taboo. Whereas, you could just go and say to your male counterpart, how much do you make? It may seem unwise, or weird or awkward, but you can do it,
And I'll add one thing to that in terms of monitoring from the government side. Felicia briefly mentioned during the presentation that there's an agency called the Office of Federal Contract Compliance Program. What that office does is they monitor the operation of the federal contract companies. Some of you may know, or I guess a lot of you know, a lot of big tech companies, they are federal contractors, which means they provide their products and services to governments, state or federal. And because of that kind of business relationship, they are subject to a higher standard of compliance. So the cases that we mentioned, the case about Google and Microsoft, as well as the very recent case that DOL brought against Oracle, I think that's one big leverage that the OFCCP is using to force or urge companies to comply with their anti-discrimination laws. So if the company is that kind of federal contract, I feel like they would be more cautious about how they implement their anti-discrimination policies and procedures. Okay.
And I think
So-
we're about at the end of our time, so if you guys would like to do a closing comment, and I think that Felicia and Ella have agreed to hang out, and maybe if some of you have questions one-on-one that you'd like to ask, if you guys
Yeah,
want to.
we'll be out in the lobby for a little
Yeah.
bit. All right. Thank you,
Well-
Bonnie. Thanks, everyone, for sitting through this.
Thank you.